Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota, and I'm a little bit quiet today for a couple reasons. One, if you don't know, I'm not home. I'm not home, so I have to respect those around and their sleeping schedule, which is different than mine, obviously. So I've got to be a little bit quieter than normal. Maybe not ramp up to like uproarious laughter, but we're still gonna have some fun. The other thing is I am sick, and I have been for the past several days, so that's why there haven't been as many. Goodness gracious. I'm going to try and keep that to a minimum. There haven't been as many streams lately because I've been kind of just chilling, laying low, letting that not happen as much, letting the voice relax and everything. But in a surprise filing, we've got Wick Phillips whining that their expert didn't expert expertly. So apparently Wick Phillips very disappointed in the monetary performance of Jason Lemoine. Lemoine did not get the fees that he was supposed to get. And so the question becomes, well, are they going to get paid? Maybe. Maybe not. You guys have 280 grand laying around? Most people don't. Most people don't have $280,000 to pay an attorney, which I'd say, is there somebody, it's almost like there was someone who said that. Who was that? Who said you can't afford this? You can't do it. No one can afford it. It's way too expensive. Who? Oh, yeah, that was me. That's right. I said it for months and months and months. You can't afford this. You can't afford it. Now, I know their lawyer told me, oh, don't worry. It's TCPA. We'll win. We'll get the fees. We'll get the fees when we win. No problem. We'll get the fees. I mean, we'll still bill you. We got to bill you, but we're going to get the fees. Don't worry. We'll get the fees. Yeah. No. Let me tell you, it's rare to find a lawyer who will do the work for free with the promise of getting paid by another person, especially in a state where they know it's notoriously difficult to collect. In fact, Lemoine likely advised his clients that even if they happened to lose, that it would be very difficult to collect because of their situation. I mean, Ron's got a wage you can maybe garnish, but Monica, her income is variable, right? She's like a self-employed sort of thing. So in the same vein that Vic is. And why is the focus on this? The focus on this is terrible. Why would it autofocus at 60? Try and sharpen it up here. No. Sorry about that. So he knows. They know they're not going to get, or they're not going to be able to collect the money very easily, right? So the crazy thing is, he likely told them about this, about how difficult it is to collect, which means he knows that it would be difficult to collect from the clients, so or from Vic if they should prevail. So likely, he's like, well, you'll have to pay us, but don't worry, when we collect, oh, Vic's got a lot of money, right? When we collect, then you'll be reimbursed, but you got to pay us because we're attorneys and the work that we do is work. and there's staff involved. Like your billable rate, Lemoine bills $500 an hour or whatever it is. Lemoine doesn't make $500 an hour. Do people know this? Do you guys understand this? Your billable rate is not your income, okay? Lemoine is likely on some salary agreement where he makes a salaried amount, and then if he's actually a partner at Wick Phillips, as they kind of claim, then he probably has some sort of profit sharing as his partnership agreement. You buy in as a partner at some percentage, you get a profit sharing or whatever, and that's where the real income comes in, is the firm making money. Well, for the firm to make money, you got to collect them bills. And if you rack up $280,000 worth of bills, I mean, that's work that you allegedly have done. By the way, $300,000 now. $300,000 now. Let's not shy away from it. If it was 280, it's now probably up to 3 because they've had some additional filings. They've had more video to review because someone actually sent me a chart, an Excel spreadsheet where they cross-referenced the filings, what they could with the redactions that were in place. They cross-referenced the filings with mentions of me and updates on the GoFundMe, and determined, and I don't know if this is accurate, I don't know their methodology, but they determined approximately $31,000 of billing was in reference to me or the GoFundMe. So, hey, Monica and Ron, you're welcome. You idiots. You hired some moron who would sit and obsess over me rather than just get your case dismissed right away, like a real TCPA expert. That's almost as much. Lemoine spent almost as much of your money as I thought it would cost to defend this through the initial stages. I said somewhere around 50. Now you happen to find a moron who charged you $280 for what Sam Johnson was able to do for under 50. So more power to you. The most capable attorney on your side did it for a fifth. Less than a fifth. Almost a sixth of what you guys paid. But that's cool. That's fine. Good job. Winner. But anyway, the point in all this is you still have to pay for this, or you're going to get billed or whatever. And your attorney may work something out with you. We'll work something out. I mean, we know it's very expensive. We'll work something out. It tends to be a payment plan, right? Because law offices, you got an independent attorney, maybe you'll work something out. He'll work for free or whatever on a contingency, sure. And you can do contingencies at law offices. Those, usually they're picking defendants that they know they're going to win against, insurance companies they know they can pay and will pay right away, all of that stuff. But you got a big firm like Wick Phillips. That $280,000 was going to be done somewhere. That it happens to get done on your case and you don't happen to want to pay isn't really the firm's problem. That's your problem. So you don't get to collect those fees. Sorry. I tried to tell you. The best part is, Ron, you deleted your Twitter. You locked it down. No one can even see your tweets. Imagine this. If you had just done the damage you were going to do and then kind of said, well, maybe I went too far, and apologized in the most pathetic way possible, like, oh yeah, I'm sorry, I guess maybe we went too far, we don't really like the guy, but maybe we shouldn't have called him a rapist or said he was a sexual predator, and I guess he hasn't been to jail, so I'm sorry about that. Like, that apology and doing what you've already done, which is making the tweets inaccessible to the general public, you probably could have settled for $0, you idiot. You probably could have avoided all of this. And you would have healed that rift in the anime community that you so mad that I created, that I did that, you know. Not that you did. I mean, you guys were innocent of all that. But you probably could have just avoided all of that too. Or you could have made me look like the bad guy and you guys could have mended the community right away. You could have done that too. Why didn't you? Why didn't you do that? You dummies. Oh my God. Imagine you're you. Not Ron and Monica. They don't even want to imagine they're them. I'm saying you, the viewer. Imagine you're you. And you have a community that you allegedly care about. And the community that makes you money. And you do something and you go maybe too far. And someone outside of that community comes in and drums up a bunch of stink about what you've done. Okay? I'm taking this their way. Drum up a bunch of stink about what you've done. And suddenly the community's like, wait a minute. We don't really like what you're doing here. We don't like this. Maybe you guys want to explain some things, and they're giving you opportunity after opportunity. Hey, you want to produce some evidence of this, and what you, instead of saying, oh, we're gonna produce it, we're gonna produce that evidence. It's coming. That evidence is coming. Don't worry, all that evidence is coming. Like, instead of doing that, what if you just said, you know what? This got way out of hand. We didn't ever want anything like this. This outsider came in. And you can blame the outsider, and then you can take a moral high ground and a community high ground, and you can preemptively seal the rift that's coming. And you can blame the rift on the outsider and other commentators and stuff like that, and you can just shovel all of the negativity onto someone who wasn't in the community to begin with. And not spend a year paying hundreds of thousands of dollars and talking to a wheezing moron. Oh my God, why didn't you do it? Dumb, 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 dumb. Dumb. I can't believe it. I can't believe you are that stupid. I told you at the beginning all of this stuff. And you didn't listen. I don't know why. But anyway, you know, not that I'm a prophet, far from it. Just a guy who knows how painful and annoying lawsuits can be, how long they go on, how expensive they get. That's all. Not even special in that way. But yeah. Anyway, well, what we've got today is we've got this surprise filing where, again, Wick Phillips now, not Lemoine from, I don't believe he's the one who drafted this. Wick Phillips has asked for a partial new trial, reconsideration of the definite victory that they got, that big win, hugest of wins. The one they've gotten so well, they're tired of winning with it. So what they've done is they've asked the judge to redo it because it's not enough. They're not getting the money that they need. Remember, he cut them out of $180,000. And I think maybe they realized that his order might not even be enforceable as it stands with the contingent fees. But we'll take a look. Now, of course, I couldn't be right about that, could I? I'm sure that you know, that I was not correct about that. I'm 100% positive that Law Twitter was firmly opposed to my statements about Judge Chupp's order. But we'll have to see what Wick Phillips says. I don't know. Cypher Warrior says, I know where you are. Me too? Are you the weirdo who emailed me? I got some crazy emails from the guy. Remember I got that weirdo emailing me the other day? I got so many of them. I just haven't been reading them. I think he's really, really sad that I'm not reading them to you. But I was getting a mixed response on the emails. Oh, okay. So Cypher Warrior didn't email me. Okay, it's not you then. That's cool. But yeah, I got the guy who was emailing me the weird stuff. I got more of those, but I haven't been sharing them because I got a mixed response from you guys. They get really wordy and really, really stupid. So I haven't been sharing it. So anyway, maybe I'll share them in my Discord, which, what a great segue. Let me advertise the Discord. If you want to join the Discord, it's patreon.com/lawsplaining or newproject2/Rekieta Law. And you can join the Rekieta Law group and hang out in the Discord and do live chats and all of that stuff. And it's a lot of fun. And it's its own community. It's $5 a month for Discord access, and then there's $10 and $20 levels. You can read about it. I'm not going to waste a bunch of time, but definitely check them out if you want to hang out with some really good people and have some fun conversations and ask me for masturbation advice. All of that is available to you. So okay, but I do have the documents. Oh, there's 2 other documents that we're gonna go through. Excuse me. Chupp is late. Chupp is late on his findings of fact and conclusions of law. Okay. As I said, Chupp was late, and they have filed their notice of lateness to Chupp. So we'll go through that real quick. It's a very short document. And then I've got an update on Christopher Hook. Now, I know many of you did not see the Christmas episode. The Christmas episode was kind of last minute, off the cuff, and I played 17 minutes of audio of the hearing in which the judge was just aching to shove his tongue far into Christopher Hook's butthole. He was very, very angry, and he was just chomping at the bit. And so we listened to that. It's 17 minutes of audio. Pretty interesting stuff. Interesting to see how much of a giant baby a 75-year-old judge can be. But they have clarifying minutes of that hearing actually published now and filed in the court case. So we're going to go through those minutes and take a look at what actually the judge ended up ordering in the court record, because it's not really clear. I mean, some of it's kind of clear in the case, but there's some weird stuff that is not consistent with how the hearing was going, and it's a little more realistic as to what a judge can actually do in the situation they were in. So that's something to remember. Judges can't always do what they think they can do, and so we've got the minutes clarifying what the judge actually was able to do based on what's on the record. So we'll go through that. Judges like to spout off, but they're just people, right? They're just normal dummies like everybody else. They just happen to be wearing a robe. Oh, I am so sorry for the coughing. I've been trying to avoid it. All right. Def not Ron Snack Tray Toye. Says, first, late and gay. Second, unmute yourself, boomer. Third, has anyone ever hired opposing counsel for a malpractice suit? Oh, God. That may have happened somewhere. but I doubt it. But maybe not. I don't know. Maybe that has happened. Finally, do lemon laws apply to lawyers? Hopefully. Asking for a friend. Also, shut up and take my money. Will do. Gladly. Mithrin Emrys says, we'll get the fees after charging for 3 people to do the same work over and over and over again. Looking through the redacted billing, they replicated so much work it is ridiculous. Sketchy, Lemon Boy. Very sketchy. Well, I'm not going to accuse him of lying to the court about the fees. But I think they lied to the court about the fees. I think they did. I don't know that they did. I can't imagine them actually billing that much. But I think they lied to the court about the fees. Because they're bad people. Wick Phillips is a lying law firm. They're terrible people. They've demonstrated it here. RZEQDW says, back in America where smoking is sadly still illegal. Thanks for hanging out over Christmas. Here's hoping 2020 is better than 2019 was. Yeah, man. Definitely. Definitely. Glad to see you back stateside. But I do hope for a better 2020, especially for you, buddy. Nunya Biz says, Lemoine wants this case to close in his favor fully because he likely has 100% origination and billable percent for this case. If closed in his favor, that will have a positive impact on his future revenue share in the partnership. So there you go. McIntyre Art says, know what's good for any illness? Shameless self-advertisement. Checketh out some of my Warhammer art on Twitter, at McIntyre Art. I've got Imperial Fist, Death Guard, Marine Exemplar, Raven Guard, and now a Black Templar. Very cool. Asphyxiation says, I want a 2% cut of the Patreon / new project too if I'm giving professional autist advice. Also, late Merry Christmas and Happy New Year, you wankers. Also, Nick, my family made pumpkin pie with Fireball in it. I couldn't hide my disgust, he says. That's disgusting. That is absolutely horrifying. Why? I mean, I know Australia is full of like all of the poisonous things on the planet, but that's worse. Ugh. If New Zealand hadn't just turned over like 10% of their guns, I would advise them to invade you and take you over because of that pie. That's disgusting. Tucker, thank you for the donation. There's no message attached, so. All right, guys. I need real medicine here. I'll be right back. Okay. Oh, whoops. It was a little more than expected, but that's fine. That's not a cabinet. It kind of looks like a cabinet. It's actually a painting. It's the frame of the painting. Oh, Tucker, just tag me then. I'll read your message. See, it's a painting. And behind you, those are window shutters. It's not a cabinet either. So. Siren Jag, this is the throat cure. I don't know if you'd love to hear me debate Leonard French. Okay. F says, hello, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. A wonderful evening to you. Who is J. Swan Lemoine, and do you have a preferred whiskey? Speedy recovery, if that were ever possible. I can relate. My preferred whiskey is... Oh, man. I think it's still Lagavulin, 16-year. Is just a great go-to whiskey. It's just my go-to. I did have Blade and Bow bourbon. I had Blade and Bow bourbon. If you follow me on Instagram, not that any of you should, I rarely ever update it, but I went to a place called Dr. Barbecue here in Florida, and I posted some barbecue pictures. And there I had Blade and Bow bourbon with my barbecue. It was magnificent, magnificent. Okay. Myth or Nemmer says, wait, are you saying that Leonard French, Popat, and the rest of Law Twitter pleasuring themselves about the judge ordering Hook to resign from the legal profession was premature? Shocked, I tell you. Shocked I am. Yeah. District court judges can't order an attorney out of the profession. You just can't do that. PG and White Knight says, pulled over to send this. If Lemoine gets his wish on a mistrial, can Chupp bring everyone back in? Also, would be a shame if people could find evidence of affairs on the other side. Short answer, yeah. If the judge has maintained jurisdiction and can pull reconsideration, then in theory, yeah, he could reopen it. He could go back. They haven't asked for that. Now, I assume either Beard Harris or Martinez Sue will respond to this motion. And I don't know, they'll probably just, requested it be denied and go to appeals where it belongs. But they may argue in the alternative that they do the whole thing over. Since lots of stuff was wrong. Lots of evidence was ignored. All sorts of things were not done well. Catherine Tucson is still fat. All of those things. It would be a shame if people could find evidence of affairs on the other side. That'd be funny. Dave Flannery says, hey, Nick, happy holidays to you and your family. Hope you are feeling better. Getting there. Love the long streams, but huge fan of the shorter, in-depth topic posts as well. Yeah, and I'm really annoyed. I have one on pornography coming out soon. Why pornography is protected speech, because that's kind of a topic going around. I've got some more to do on the impeachment. I want to do just little quick hits on stuff. And I really want, when the transcript comes out, I may do a short video just hammering in the finer points of the transcript really quickly, and then, go into a long video about it as well. But thank you. I'm working on it, and when I get back home, you'll probably see a lot more of those. I really want to have multiple short videos a week, maybe even supplanting some of the live streams. So we might cut down from 5 expected live streams down to 3 or something. I don't know yet, but more of that happening. Moist John. By the way, Tucker, did you ever send me the thing? There it is. Tucker says, Leonard French is such a cuck for his take on Hook, but he runs with Law Twitter, so I should have expected it. Yeah. Everybody wants them Pope Pat gummies. Moist John says, had my 21st a week back and got a Lagavulin Distillers. I know it's heresy, but I think I prefer Lafroig. It's not heresy to prefer Lafroig. Not heresy at all. It's It's just taste. I like Lagavulin a little bit better. It's got less tar in it. Less anus. Blaine20 says, you're in Florida and didn't stop by. Meanie, I'm still in Florida. It's not that I haven't stopped by. DM me, Blaine. See if we can get together while I'm here. Okay. Let's jump into this stuff while we're here. Oh, YouTube is doing a weird thing with the super chat window. Lovely. It's cutting off the most recent one. How annoying can they get? It's because I'm on a short monitor. Aha, I fixed it. Okay. Yeah, that's where I am, Cypher. That area. Okay, where are we? What am I doing? All right, we've got notice of past due findings of fact. Just a second. Alrighty. All right. Solo. There it is. I did it right this time. I'm not on my regular computer, and everything, like the resolutions are different, screen sizes are different, and I just want my things. I just want my things back. Yeah, Flash, why aren't you here in Florida? My buddy and I polished off an entire bottle of Berkelatic the other day. It was absolutely magnificent. Berkelatic. Okay. So here is the past due findings of fact and conclusion of law. This is the very, very brief notice, that Chupp is late on his findings of fact and conclusions of law. Defendants Monica Rial and Ronald Toye, collectively, soy style, in the above styled and numbered cause, hereby give notice of past due findings of fact and conclusions of law pursuant to Texas Rule of Civil Procedure 297. On November 26, 2019, defendants filed their request for findings of fact and conclusion of law, and such findings of fact and conclusions of law were due to be entered by the court 20 days thereafter on December 16th, 2019. Now, they filed this on December 20th. Their deadline to file this was December 26th. So they got it done before Christmas. Good job. And it was signed by Rusty J. O'Kane, who is a lawyer at Wick Phillips. So, man, now they're just adding all kinds of people for this this post-judgment motion practice and appeals. Monica and Ron, you thought it was expensive so far. It's only going to get more expensive. And the funny part is the odds of you winning fees on the rest of this go down from here. So now you're going to be forking out that money just to hopefully keep what you think you won. Just keep forking out that money just to hopefully keep what you think you've won. And you can still lose. I hope they've covered that with you. I hope they have covered the fact that they know that TI could come back. And if TI comes back, you don't win much of anything, and you may lose whatever you think you've won. Sorry. I hope they've covered that with you. Was that an uncomfortable conversation? Did they lube up before that conversation? Did they have you do some Kegels and calisthenics and get ready for it and really do the stretching and getting ready for the possibility that on appeal, especially that TI, comes back? West Nile-chan says, Nick, use this money to see Rise of Skywalker. Bring Ty. I don't know if Ty will be around. I don't know if I'll be around Ty while Rise of the Skywalker is still in theaters. Is it even still in theaters? I don't know. But well, I'll see what I can do. Crusader Saracen says, as Lemoine files another frivolous motion in court, Judge Chupp grabs bug sprayer and yells, out! Out! Back to the 60s! Back! There's no place for you here in the courtroom! Get out while you still can! Dude. Thank you. I needed a James Earl Jones Field of Dreams reference in my life. I really did. Oh, God. Okay, so this is very basic. But the recap of this is when Judge Chupp ordered the attorney's fees in a crushing victory for Monica and Rontoye, he didn't provide his reasoning for why he gave them $100,000, but then left on the table $180,000. So he didn't tell them how he came to that number. So they have asked him for his findings of fact and conclusions of law. He has 20 days from the time they asked to go ahead and do that. He hasn't done that. He didn't meet the 20-day deadline. So then they get a 10-day window to remind the court that they're asking for that. And at that point, Chupp gets 20 more days from the original time, which was December 26th plus 10 more days. So November 5th or January 5th or so that Chupp will have. The remedy for not providing findings of fact and conclusions of law is appeal. You can appeal, which they already have. So Chupp has no real reason to do what he did, or to do what they're asking. He probably will, maybe, but he has no reason to, because they've already appealed the fee decision. They've already appealed it. So if he just doesn't provide findings of fact and conclusions of law, that'll be subject to appellate review. It's appealable. Now, fees are not a de novo review. This is something I think that's gotten lost. Fees are reviewed as abuse of discretion. Fee awards are reviewed as abuse of discretion, which is a little more specific and a lot harder to deal with, okay? When we're talking about fee amounts, because the fee amounts are within the discretion of the court. So if you think the fee amount is either too big or too little, you have to argue that the judge abused their discretion, that the award was so unreasonable that it must have been an abuse of the judge's discretion to come to that conclusion. Okay? And it's a lot more specific. A de novo review is where they're just going to look through the things kind of from the start and make their own determination, right? What's in the record, based on what's on the record, what do we conclude? We don't really care how the judge got to his reasoning on de novo review. We care a lot about how it got to his reasoning on abuse of discretion. Well, I shouldn't say that. Not that they care a lot. It's that they look to what's in the record, and then they look to whether or not what the judge did was unreasonable, basically. Does that make sense? I hope that makes sense. It's a weird thing to explain, but the long and short is they've got to find out if Judge Chupp's fee award was so unreasonable that he must have abused discretion, or whether it was reasonable to the point where it's within the court's authority to do so. That's why changing a fee award that's been issued, that's in the middle, is really, really tough. And Chupp put them in kind of a difficult place at this point, because they can request an appeal for abuse of discretion, but the appeals court's going to look at this and say, well, they asked for a bunch of stuff. The judge gave them less than what they asked for, but he still gave them a lot of money, right? $100,000 is a ton of money. And they got to say, you know, is that so far? Is that an abuse of the court's discretion The other side argued that there's a bunch of frivolous billing. This is all in the record. How are we going to... The judge is probably the best person situated to review this evidence and make that determination. So they've got to find out if it's too much or too little. Now, if he awarded every dollar of what they asked for, you'd actually have a good argument that abuse of discretion, because the amount is so big, would come down. Evan Stone knows this. Evan Stone knows this. He's been involved in cases like this. I'm pretty sure Lemoine knows this too, and Wick Phillips knows this too, but they've got to try. But anyway, so it's a little different than the de novo review that the TCPA itself has. Abuse of discretion would be on the amount of fees, okay? Now, if the judge had awarded either all of them or $0, they would have a great argument. Either side would have a great argument for abuse of discretion. When the judge splits it, gives somewhere in the middle, it gets really muddy and really complicated. And courts, appeals courts, for whatever they're worth, don't like to overturn things on abuse of discretion because they're not hearing the evidence. They're not involved in the case and how it progresses. They don't have a feel for how much this should have cost based on what came before the court, right? Like, that's a big thing. Judge Chupp knows what was actually brought into his courtroom. The appeals court can look at the review, but Judge Chupp has the sense of it. And that's a weird standard, right? It's not a standard. It's not something that you can quantify, but it's the judge's feelings. It's like the courts defer to cops when cops have some sort of gut feeling about danger. And they give them a lot of leeway because the court isn't on the street. Some of them should be, but they're not on the street there with the cop. So they're going to defer to the cop's feelings and professionalism and training. In a similar way, the Court of Appeals is going to take the word of the judge who sat there in front of these two lawyers or these groups of attorneys, and who heard motion practice before the court and who dealt with all the filings. And they're going to say, you know, if he doesn't think this was worth $300K, maybe it isn't worth $300K. No matter how many billings they put in front of us, he actually assessed the quality of the work, how they were in front of the court, how often they were in front of the court, what happened. He knows if some of this stuff was for depositions. Chupp knows about the YouTube stuff. Chupp knows about it. I don't think he watches or anything like that, but they told him about it early on. And he knows about the popularity of the case. So he knows that some of this is showboating, showmanship, all of that stuff. Chupp knows. At least the appeals court will assume Chupp knows, and that he made his decisions based on that. So all that to say that changing a fee award that is in the middle is a really, really difficult task for them. Okay. Cesario JPN says Malika Likimaka. Malika Likimaka, Happy New Year. And New Year's Chinese zodiac animal is the rat. Also, did you know Leonard French gave notice to Univision over a DMCA copyright claim on using public domain C-SPAN clips? Nope, I did not know that. Good job, French. Siren Jack says, Ron and Monica don't need kegels. They've been smuggling frozen butter balls out of Kroger just so they could have Thanksgiving dinner. A Wick Phillips fisting is nothing to them. It's like clanging a dinner bell. Now, you say a Wick Phillips fisting is like nothing to them, but have you considered how many attorneys it takes to fist a client? How many Wick Phillips attorneys it takes to fist a client? I mean, look at how many were on this notice. 1, 2, 3, 4. Four attorneys right here on this thing alone. All right. Let's get to the next one. So this is the new filing. This was filed on the 26th, which it's now the 29th. So today was the 28th. Yesterday was the 27th. Oh man, this was filed on the 26th was what? Oh my God, this was Thursday and I didn't even know. I'm very much on vacation. You can tell. Arctic Pride, your ignorance may or may not be intact at the end. Your ignorance and your innocence may or may not be intact by the end of this stream. I make no promises, good sir. Good sir. All right. Defendant's motion for partial new trial, or in the alternative, motion to modify the final judgment. Defendants Monica Rial and Ronald Toye, and collectively with Rial, defendants. Look, Rial is always a collectively, even when she's alone. File this motion for partial new trial, or in the alternative, motion to modify the November 25th, 2019 final judgment motion as follows. Now, this is interesting. This might be timely. Might not. There's not a hard and fast rule on the motions on a motion for reconsideration. Rule of thumb is 30 days, but once it's out of the court's jurisdiction, they tend to be not viable. So this is interesting because I'm not sure they can file this now that they've filed an appeal. And the appeals court has dismissed, or has, okay, so the appeals court denied their motion to dismiss, which means, let's rewind. Let's rewind. Ty and Company filed an appeal, okay? They filed it prematurely, all right? Because there wasn't a final ruling on the fees and costs. Now, the way appeals work in Texas is there's a rule that says if you file it early, it becomes effective when it should be effective, okay? So the early filing doesn't really hamper you. Now it can if the thing's filed like a year early, they're not going to hear your appeal. They may dismiss it, reopen it, whatever. Doesn't matter. In this case, what happened is Ty filed the appeal possibly premature. Doesn't really matter because of the rule, but possibly premature. Lemoine files a motion to dismiss the appeal for lack of jurisdiction of the appeals court. Now, to explain the mechanics of how this works, okay, the appeals court can't have jurisdiction over an issue unless it's interlocutory. They can't have jurisdiction over an issue while the district court still has jurisdiction, okay? Can't have two courts of jurisdiction. One court gets a jurisdiction, the other one doesn't. So if the appeals court doesn't have jurisdiction, the district court does. If the district court does have jurisdiction, or doesn't have jurisdiction, then the appeals court does, all right? That's how this works. Now, they filed their motion to dismiss. Before the appeals court had the opportunity to review that motion to dismiss for want of jurisdiction, specifically, okay? The final award came in. That was on November 25th, the final judgment, okay? Once that happened, the appeals court then takes up that motion to dismiss and denies it. That was in December. I did a very short video on it where I just laughed a lot. That's about it. So once they deny the motion to dismiss for lack of jurisdiction, that means that the appeals court has jurisdiction. Are you with me? Motions for modification of the judgment, motions for new trial, motions for reconsideration often require that the district court still have jurisdiction over the case to go ahead and modify the existing order. Are you with me on that? If they have jurisdiction, they can issue orders in the case. If they don't have jurisdiction, they can't issue an order in the case. Now, not only did they deny the motion to dismiss for lack of jurisdiction, pretty heavily implying that the appellate court has jurisdiction over this matter, but Wick Phillips has specifically asked the appellate court to take jurisdiction. They have filed their notice of appeal. Because of that, I don't know that this motion is anything but frivolous. Okay, does that make sense? Are we logically following this? Because if the district court requires jurisdiction to issue an order, which they do, the court must have jurisdiction to issue an order in a matter. And they don't have jurisdiction because the appeals court now has jurisdiction over the matter, then the district court may not be able to issue an order on this motion, which makes this all a waste of everyone's time. And specifically, and by the way, as you guys can tell, I have clearly diverted the GoFundMe money to Wick Phillips specifically to troll Monica and Ron and to do things that cost them money and produce no result. So, Monica and Ron, you're welcome. I paid off Wick Phillips. I have bribed them personally just so they will waste your money. Because you're not winning this. This isn't going to your TCPA. You're paying for this. You're paying for every dollar of it. So that was me. That was me paying them off with the GoFundMe. They were after the whole time. It was really easy. It was really simple. All I did was I said, Wick Phillips, all the GoFundMe money will be yours. All the new GoFundMe money, I guess, will be yours. Because, I mean, you know, GoFundMe, they don't know, but you guys know the GoFundMe. So it was like a double secret troll on both of them. Because I told them I'll direct the new GoFundMe money to Wick Phillips, which just means, obviously, that they're not getting anything except what comes in new. Because all the other stuff is paid out. That's how GoFundMe works. So just so you know, Wick Phillips is now in on the gag. They're just wasting Monica and Ron's money, and that's how it goes. So, oh, by the way, another shameless plug. If you're not following my Rekieta Media Twitter account, please do so. If for no other reason than I can go ahead and get back on track to passing Greg Douchette in Twitter followers. Losing my Twitter account was a real shame because I would be past Douchette in Twitter followers by now. But we're on a new mission. We're on a new mission to get back up there and pass him. We're at 9,000. You can find all of the fat jokes you want, as well as show announcements and stuff. And if you don't like Twitter, don't worry about it. But if you're on Twitter anyway and you're not following at Rekieta Media, make sure you follow it. That is the official Twitter account of Rekieta Media, a Texas limited liability company. All right, so here we go. Long story short, I don't know. Shouldn't say I don't think. It's too definitive. I'm a lawyer, for Christ's sake. I don't know if the court can even issue an order on this. They shouldn't have authority. The appeals court should. The appeal isn't interlocutory. It's an appeal of a final judgment. That's implied by the denial of the motion to dismiss. So I don't think they can. Dang it. I don't know if they can. Don't think they can either. So they're just literally wasting Monica and Ron's money. And that makes me so warm on the inside. The next time I go to Wick Phillips, I may bring a box of chocolates to them. Introduction. On October 4th, 2019, this court entered an order granting defendants Funimation Productions, LLC's motion to dismiss under the TCPA. Monica Rial and Ronald Toya's motion to dismiss under the TCPA, and Jamie Markey's motion to dismiss under the TCPA, dismissing this action against all defendants with prejudice. Dismissal order. In the dismissal order, the court retained jurisdiction to rule on an award of attorney's fees, costs, and other expenses incurred in defending this action, and appropriate sanction pursuant to TCPRC 27.009. I hope they mention the fact that the appeals court has denied that motion. I hope that happens. Thereafter, defendants filed their brief in support of sanctions and attorney's fees pursuant to Texas Citizens Participation Act, the Real Toye motion. Plaintiff objected to the award of fees, but did not offer an alternative as to what would constitute an amount of reasonable and necessary attorney's fees, nor did plaintiff present competent evidence on the Arthur Anderson factors to determine reasonable and necessary fees. They're ignoring how the court actually deals with this, but they know that. Architect of Fate says a Wick Phillips fisting that would have 4 attorneys holding the gape open with the rest coming with their hands open to dive in. Maybe an open hand if they are late. Ouch. When are you going to EFAP Law Daddy? I always forget what EFAP even is. I know you guys know, but I don't. And you've told me before, I just don't remember. Anyway, plaintiff's response to motion to dismiss filed by defendants also did not offer competent evidence to combat defendants' calculations. They don't have to. They actually don't have to. Because the court can and did look at what the defendants filed in their motion and determine it to not be sufficient to determine the reasonableness of the fees. And the court doesn't care how many fees you incurred. The court only cares about what is reasonable, which is different. Every frame a pause. Every frame a pause. That's right. That's right. I'd love to go on their show. Love to go on it. Because there was no contradictory evidence presented to the court, the full amount of fees, $270,963.04, presented in defendant's motion should have been granted. That's not how this works. That's not how this works. You know that's not how this works. On November 25th, 2019, this court correctly concluded that defendants should be awarded attorney's fees and sanctions. It's in the law, yes. But entered a final judgment wherein it awarded $100,000 to defendants against plaintiff for defendants' reasonable and necessary attorney's fees, plus the amount of $15,526.96 in litigation expenses in defense of this matter through November 21st. The court awarded defendants their appellate attorney's fees if plaintiff appeals the final judgment and there is no modification or change to the final judgment. And this might be allowable, but I don't know about that. The final judgment includes 2 specific errors or issues that require the court to grant a partial new trial, or at least to modify the final judgment. Specifically, the final judgment awards defendants an amount of attorney's fees $100,000 lower than the amount requested. An amount of attorney's fees, $100,000, lower than the amount requested and supported by competent evidence in defendant's motion, $270,963.04, and awards conditional appellate attorney's fees in the event there is no modification or change to the final judgment or the final judgment is affirmed by the Court of Appeals. This should be modified to grant conditional appellate attorney's fees in the event there is no modification or change to the dismissal order. Change to the final judgment or the final judgment is affirmed by the Court of Appeals. Okay. Defendants move for a new trial or in the alternative to modify the final judgment as discussed below. And E Productions nailed it. $270,000 is not reasonable. It's not. Not in this case. Reminder, $270,000 is close to what Trump's attorneys were awarded for filing a TCPA. Trump being the president of the United States, filing a TCPA in federal court in California applying Texas law to the president in a public dispute with a celebrity. Think about that, all right? You've got the president of the United States publicly arguing with a porn star on Twitter, which is national news, about his alleged prostitution / John relationship with her. Can we wrap our minds around the Stormy Daniels thing? The president is arguing with his whore, who also is an extremely famous porn star. All right? Publicly, on Twitter, she files a defamation suit. It gets bounced between jurisdictions. It ends up in California federal court applying Texas law. They win on the TCPA in California federal court, and it's the president of the United States. So this is a massively expensive case. And that's what the court determined. Now, they asked for like $340,000 in attorney's fees. They were awarded $280-something thousand in attorney's fees. Because of how unique this case is, right? You've got complex jurisdictional issues. You've got the TCPA, which the Ninth Circuit applied the TCPA in federal court. The Fifth Circuit ruled about 8 months later that the TCPA does not apply in Fifth Circuit federal courts. The Fifth Circuit is where Texas actually is. So think about that. You've got no authority applying appellate fees in the Ninth Circuit. It's probably a case of first impression in California, applying the TCPA in the Ninth Circuit. You've got lawyers representing the president of the United States against a porn star that he paid to bang. All of this stuff. Like, you have this massively complicated set of facts, right? And that cost, according to the court, almost as much as Lemoine is asking for in what is really a run-of-the-mill defamation case. Like, let's be honest. Vic's case isn't particularly special other than who's involved and how special all of them are, right? But really, this is people lie to get someone fired and to ruin their reputation. That is the normal defamation case that's out there. We're not talking about a public figure verified on Twitter arguing with the president of the United States on Twitter about their sexual affair that the president allegedly paid for, and then allegedly paid another attorney to allegedly threaten the porn star to cover up. Like, this is crazy compared to the Vic case. And Lemoine's asking for almost that much money because he couldn't stop jerking off to me on YouTube. That's embarrassing. Absolutely disgusting. Absolutely terrible. So, yeah, you nailed it. It's not reasonable. Look, I don't like it either, but e-thoughtery has its costs. I'm officially an e-thought now, and I have to bear in mind that a West Nile pneumothorax riddled attorney in Texas may just be pounding one out to my face on his screen every night and billing clients for it. I have to consider that possibility. That's part of the e-thought game, and I am in the e-thought game. All right. Okay, let's see what they say. Court may grant a new trial or set aside a judgment upon a showing of good cause. Texas Rule of Civil Procedure 320. Texas courts are afforded broad discretion in granting new trials. A trial court has plenary power to grant a new trial or to vacate, modify, correct, or reform a judgment within 30 days after the judgment is signed. Final judgment was signed November 25th, 2019. Do we count the days? November 25th. 6, 27, 29, 30. That's 5. Okay. Now December 1st, 2nd, 3rd. Wait, so we just get to count 25 days. 30 days. 30 days would be December 25th. Final judgment was signed November 25th. This was filed on December 26th. I don't know. That sounds like 31 days. Oh, I know it's a holiday. But the court loses its plenary power after 30 days. I don't know that the holiday filing time applies to this. You guys say it's fine. They give you 1 day after the holiday, and it may be fine. But it might not be fine. Let's see. When did they file this? It's filed at 7:58 p.m. This was filed after the close of business on the 26th. Now, I don't know, but maybe one of you aspiring people out there will look it up, but don't you have until, you might have until 10 a.m. the next day? 26th was Thursday. Might be 10 a.m. the following Monday for answer documents. I might be thinking of that. I don't know. But when does the court lose its plenary power? Typically at 30 days. They knew this was coming. They could have filed this at any time before that. I would argue they don't have it. I mean, you obviously argue they don't have the plenary authority. You similarly argue they don't have plenary authority because the appeals court has already accepted jurisdiction, and that's the most important argument. Because the real question is, can the district court have plenary authority when the appeals court has accepted jurisdiction? And that answer may be no. I don't know. Like, I'm not saying definitively. I'm saying the arguments you would make. You would definitely, like if you're Vic's attorney, you definitely argue that the court no longer has plenary authority to do this. Absolutely. This goes to the appeals court, and that's where it should be. Because think about this. Appeals have been filed. Appeals have been accepted by the appeals court. So if the judge now modifies its judgment, now modifies it, that means what are you appealing? You're appealing the old order, which is now mooted, so you have to file a new appeal. It's cumbersome. You would argue definitely that the appeals court accepting jurisdiction means that this court no longer has the plenary authority to modify, correct, or reform a judgment. And the worst part is, and this is again what you argue, not only do plaintiffs think that the court has no more authority, defendants have already filed their appeal and similarly agree that the court has given up jurisdiction as they have submitted to the appeals court. They've submitted to the jurisdiction of the appeals court. Again, what Chupp will end up doing, guys, what do you think Chupp's going to do here? Do you think Chupp's going to modify or vacate his order with the pending appeals? Why in God's name would he do that? It will just get appealed. The appeals court is already going to review this. There's no way Chupp goes ahead and does it. I mean, maybe he will. I highly, highly doubt it. Based on Chupp's activity so far, he is happy to kick this to the appeals court, let them review the case, and go for it. He could have done a lot of things. And this is a strategy question that Vic probably had to deal with his attorneys. They could have asked for a modification. They could have they could have asked Chupp to reconsider his judgment, right? Especially when they got the order with no findings of fact or conclusions of law. What they could have done is requested a finding of fact and conclusions of law, and then filed a motion to reconsider, or they could have just filed the motion to reconsider and said, look, Your Honor, you at the hearing, you asked for this, and this in the record. And while in the confusion of the hearing, we weren't able to provide it, it is a part of the record here, and here. We've gone back, we've reviewed these timestamps of the transcript of the hearing, and you can go ahead and see that this, you asked for evidence of a contract. Well, here is the evidence of the contract from the complaint, right? We stated that these are contracts. We stated how partial performance had occurred in the contract, or how performance had begun in the contract by the announcements of Vic Mignogna, and how that constitutes and shows the existence of a contract. Even if there's not a paper agreement, it shows that there's a contract, and oral agreements are allowed in Texas. And not only that, but the defense knows it because the defense is familiar with the business because they engage in the same types of oral contracts with convention managers. So there's your evidence of contracts. You asked for evidence of a defamatory tweet from Jamie Markey. You actually had just discussed a defamatory tweet with Jamie Markey's counsel, Sam Johnson, one in which a TDMA takedown letter was issued. And when this specific tweet was brought up, it was brought up in court. It's listed in the filings here, and here. You can go ahead and review them. So if you wanted examples of a defamatory tweet, they're here. Those were in the record at the time of the hearing. They were actually brought up at the hearing. Here you go. You wanted evidence of TI from the defendants, blah, blah, blah. They could actually have filed that motion, a motion to reconsider. They could do it. However, if they won on that motion for reconsideration, a couple things occur. One, they'll get an interlocutory appeal from the defendants. Two, they may not be able to appeal their issues if they won on one single issue. They may have to take that all the way to trial before Vic would get his opportunity to appeal. So think about this. If Vic wins just on the TI again at TCPA, just on the TI against Monica and Ron, all right? They now have to litigate that case for another 9 months to a year before they get to appeal Monica, Ron, Funimation, and Markey's defamation actions. So if they win on that motion to reconsider, it may cripple their ongoing effects. Or they can appeal the whole order and let the appeals court go in piece by piece. So this is a strategy question that I don't know if Vic and Ty had a discussion about it, but they probably did. Because the question is, well, do we ask the judge to reconsider this and risk him bringing back, say, just the TI, which we have the text messages from Ron, which that alone should be sufficient for the TI. We have that. It's authenticated. Here it is. If we put that forward and Judge Chupp just goes for the TI on Ron, then we have to wait until that is fully resolved before we can appeal everything else. Or we can just accept the order that we have now and go to appeals. That's a strategy question you have to deal with your client, right? What do you want to do? You want to drag this out? Because then imagine they win against Ron. That's going to get appealed. But then they also appeal that final judgment. So then you've got the appeals process. Then you've got another year if you win. Or if you win at the appeals now and bring back those issues, then you've just got the year or so of litigation that continues. It's a toss-up question in how you want to do this. Do you want to bleed out your money and their money? Well, then you do it the slow way. You want to just try and nail everything in one shot. Might be higher risk, maybe not. You might lose an opportunity to get the judge to reconsider, but really it's going to go to the appeals court anyway. Just bring it to the appeals court. But like I said, the appeals court has taken jurisdiction. And the defendants have asked the appeals court to engage in that jurisdiction as well. I don't think that the court has authority anymore to modify this order. RZEQDW says, whatever happened to the Damore case? Didn't it go into discovery? Why are you not drunkenly reading Meme Gen like the Rekieta law I fell in love with 2 years ago? What is Meme Gen? The Damore case got really uninteresting to me when Damore and the other plaintiffs who were actually employed by Google got dropped from the suit. So Damore got dismissed due to a binding arbitration clause, and so did every other white or Asian male employee that had been actually hired by Google. They had arbitration clauses in their employment contracts, therefore they were dismissed from the suit. So the only people who remained were the people who were interviewed by Google but not employed. They had applied and said they were not hired based on their discrimination. Did it go into discovery? Yes. I don't know what the results of that discovery are. I can reach out to Harmeet. I would love to talk to Harmeet in general. I'd love to talk to her and get her on the show and get a status update on that case and the other cases she's doing, because she has taken on some high profile cases in the interim. But the bulk of that case got really uninteresting when Damore was no longer included, and it got a lot weaker very, very quickly. So that's to answer your question there. Dave Flannery says, do you believe that society is starting to move away from damning people on accusation alone? I think people are starting to get a bit more cautious before making a judgment. The mob has been wrong too often, crying wolf. I don't know, but I hope so. I hope so. All right. So back to this, sorry. It is also within the court's discretion to modify or clarify its judgment during the period of a trial court's plenary power. See, they rely on this plenary power, but they don't have plenary power once the appeals court takes authority. Power to modify judgment is virtually absolute. Trial court's plenary power to grant a new trial or to vacate, modify, correct, or reform a judgment is limited to a maximum of 105 days after the judgment is signed. That's a maximum of 105 days. That's not what they always get. In this case, the qualifying language to the awarded appellate fee should be modified to make clear that if defendants appeal and are successful in modifying $100,000 fee award, then the conditional appellate fees are unaffected. Did they not read the order? It's not conditioned on the defendant's appeal at all. It's conditioned on the plaintiff's appeal. Actually, the plaintiff's filing of a notice of appeal, probably after the court order. I think the defendant should be asking the court to clarify that, because the notice of appeal was filed prior to the court order. I don't know that they can award conditional attorney's fees on something that already happened, that the plaintiff doesn't get the opportunity to consider the condition. Can Chupp deny before a response to this motion? Yeah, he can. He could deny it. But I assume they'll have a response before he denies it. Remember, he hasn't even filed his finding of facts and conclusions of law. But Chupp could simply say, I no longer have jurisdiction, the appellate court has it. Do that. All right, next. The court should grant a partial new trial or at least modify the final judgment on the issue of defendant's award of attorney's fees. Defendants presented uncontroverted evidence that their attorney's fees totaled. It wasn't uncontroverted. Good cause exists here to grant a partial new trial or to, at minimum, to modify the final judgment, because the final judgment awards attorney's fees but improperly awards the same amount of fees to Rial and Toye, $50,000 each. It doesn't actually say that. That's an inference. That's not in the order at all. Now, it does award Rial and Toye $100,000, but we don't know if it awarded them $50,000 each or if it awarded them $100,000 together because of the cost of their specialist attorney. We don't actually know. That it awarded to defendants Funimation Productions $50,000 and Jamie Markey $48,137.50. Despite a lack of evidence justifying this award, we actually have no idea if they awarded $50,000 to each of them because of these two amounts. And arguably, these two amounts are different, right? We don't know. As was clear in defendant's motion, plaintiff's lawsuit was primarily directed at defendants. Plaintiff deposed only defendants. That actually doesn't matter. Attached hundreds of allegedly defamatory communications that require costly response. I'm sorry. They responded to 0 of the communications. They responded to none of Toye's defamatory tweets. Wow. And deliberately launched a strategy of creating nuisance filings against defendants to increase litigation expenses. Yeah, I don't think so. What are they basing that off of? Nothing. Defendants were required to expend more time and money to respond to plaintiff's bad faith strategy. They have shown 0 evidence of bad faith on the strategy. Judge Chupp didn't seem to have any problem with the strategy. And remember that defendants went ahead and filed all sorts of crazy motions as well. Moreover, plaintiff's legion of followers, directed by plaintiff's friend and financier. I gotta mention again, they still can't find it. They're like a man with a tumored fupa searching desperately for his own winky, and they just can't find it. I think, guys, is this GoFundMe time? It's gonna be. Let me see if I can find this GoFundMe. I don't have the easiest way to get this on screen. I'm gonna try. Let's see. See what we've got. Maybe I can do this. Give me just a moment. This is really difficult because I only have 2 screens here. So hold on a moment. Let me. Oh, I think if I do this, and which is really meta, I know. This. Here we go. Here is that there. That's right. This is the there. Okay, this is the Vic Kicks Back GoFundMe. Since it was yet again alluded to in court, we are at $267,135. But more importantly, we're at 11,200 shares. Guys, if you have not shared this GoFundMe, this case has a long way to go. And it would be very much appreciated if you would go ahead and share this. I know many of you have, but if you have, or if you haven't, and if you haven't, it's been a while, or if you've never shared it, go ahead and toss a share on it. That pisses them off so much. But we're $267,135. We've got Nikki Engler, Wesley De Aguayo, No Monica Real, and Simon Hunter, and Juan Azuara Duran. Thank you guys so much for your contributions. This has been, there is nothing on earth that could have been funnier than starting that GoFundMe. Nothing. I mean, the amount of time and money and effort and sorrow that it has ruined is just, it is magnifique. It couldn't have been planned. I never thought that these morons would focus so much on hating this GoFundMe. I legitimately thought they would be not so stupid and just open their own. Right? The reasonable thing to do, the only smart course of action, was to engage their fan base, open a GoFundMe, and make their broke ass lawyer, law Twitter, no client friends donate $2 at a time to the GoFundMe. That was the only solution they could have done. But wait, what would have happened? Imagine if we could quantify support for these losers. Imagine if we could quantify it. Maybe they aren't so stupid. They are. Because listen, Sugar Lips, even if you were getting BTFO'd by Vic's GoFundMe, you would still have whatever you raised. And the fact that Vic was raising more would make your broke friends reach deeper into their cobweb-encrusted pockets and scrounge up something. And you should have just done that. Instead of earning money with your own GoFundMe, you paid over 30 grand for Lemoine to watch videos about the GoFundMe. Think about that. Think about how stupid you are. And he promised you, oh, we're gonna win the money back on appeals. Don't worry. Don't worry. We're gonna win the money back on appeals. Trust me. Sure you will. All you had to do was open a GoFundMe, you idiots, and you didn't do it. Okay. Notice, directed by plaintiff's friend and financier. I haven't financiered Vic a single dollar. Not one. How can I be his financier? Directed by plaintiff's friend. I guess. But a legion? Man, a legion of followers directed by me? Do you know what I would pay? Guys, I would pay money to be able to direct you to do something. Because if I could direct you to do something, Monica, Jamie, and Ron would have been fired a year ago from all of their jobs. They would have nothing. If I had the power to direct the legion of people, I mean, we had 10,000 people watching Monica's deposition. If I had the power to direct 10,000 people, you think 10,000 emails a day could get Ron fired? I think maybe. I would have directed all sorts of things, but I don't direct anybody. That's where you guys are wrong. It's a shame. Man, I wish to God I was directing everybody. My job would be so much easier if I just told you what to do and you did it. But damn it all, you're independent people. Also directed the vast majority of their hate speech at defendants and their counsel. Oh, you wish. As explained in defendant's motion. Vic, by the way, Vic hasn't gotten any hate speech. Nor have I, nor has Ty. None of it. None of it. Not a single lick of it has been directed at any of us. I'm up to 10 bar complaints. 7 of them, I think, from Kick Vic. How many bar complaints did Lemongrass get? Gay and Still Large says, anyone who thinks rackets can direct people needs to join the Discord, because I think Nick would have directed Owu into not being a sinner a long time ago. I would also have directed Fatty Caddy into a better course of life. But there you go. All right, anyway. As explained in defendant's motion, defendant's counsel had to spend considerably more time and money preparing to defend against the lawsuit than the other parties. Why? Why? They didn't have to. It's not the lawyer's job. I don't know if you guys know this, but it's not the lawyer's job to defend against the mob. It's not the lawyer's job at all. So all of that prep work and the fake death threat defense and all of that crap, yeah, no one asked you to pay for that for the TCPA. In fact, if you had shut the TCPA, if you had done the TCPA right away and shut the case down, I don't know, in May, how much harassment would you have prevented if you had won in May? Why didn't you? You lying sacks of trash. Oh, that's right. We'll run up the bill. We'll run up the bill on Victor Manganagana, and we'll go after the GoFundMe money, and then we'll win the GoFundMe money by running up the bill. And then when we win the fees from Judge Chupp, then it'll be better for you because you'll profit from the lawsuit. That's what'll happen. We'll inflate the bill with lies. We'll inflate the bill with all sorts of stuff. I'll sit and watch that cute little boy in Minnesota do all sorts of things. I'll enjoy it a little bit, but I'll put it on the bill, and then you'll win the fees. And when you win the fees, Vic will have to pay more, and it'll punish him even more, and we'll win the GoFundMe money. So it'll be great. That'll happen, I promise. Right? Is that what happened, you disgusting fucking dirtbags? Hiring an absolute pile of garbage. You hired a walking pile of trash to inflate a bill on the promise that you would cost the man you tried to ruin more money. You are disgusting remnants of humanity. I hope to God you find Jesus at some point in your life, because you people suck. You suck, and you know it. You hired this guy. You planned this strategy, and don't tell me you didn't. You lied to ruin Vic's career intentionally with specificity in a coordinated effort with your ugly friend Jamie Markey, who couldn't find her way out of a donut shop if there was a forklift trying to get her out. You lied about a guy in a coordinated effort to ruin him. You were hugging and kissing this guy in December before trying to get him fired in January. And we're supposed to, over an event that happened, 11 years prior? And we're supposed to believe you? And then we're supposed to believe that you hired Lemoine and didn't plan a massive bill inflation? Come on. Oh my God. Ron, are you really that mad that Vic kissed Monica? Don't you want to watch guys kiss? Are you mad that you didn't get to watch? Little balding cuck? All right. Regardless, and most importantly, plaintiff failed to rebut the evidence presented by defendants. Thus, the entire amount requested by defendants should have been awarded. Actually, the plaintiff filed a thing rebutting most of the evidence. Saying that, yeah, you redacted. None of the redacted stuff should be awarded. And actually, this is completely unreasonable. But, you know. Defendant requests only a partial new trial on the limited issue. Yeah, why? Why don't you want a whole new trial? You think you might get hollowed out? On the issue of the $100,000 award of attorney's fees, this court may enter an award more in line with the uncontroverted evidence entitling defendants $270,000, blah, blah, blah. Final judgment awarded to defendants less in attorney's fees than is justified and supported by the evidence presented in defendant's motion. Final judgment awarded plaintiff $100,000 in attorney's fees when all the evidence submitted to the court supported an award of $270,000. Defendants filed their motion in support of their claim for attorney's fees and presented expert testimony. Oh, and I can't wait for that transcript when we get to go through that expert testimony. I can't wait for that transcript when your trial expert, Lemoine, gets to go on stand and talk about what the fees were. Well, you see, Your Honor, it cost me $50 a box for tissue paper to clean up after I watch a Rekieta stream. That handsome boy up in Minnesota, I can't take it. CE says, no, Ron is mad Vic didn't beat her with the volume button on the remote. Oh. This is a funny line. Plaintiff offered unpersuasive objections. They weren't unpersuasive to Chupp, were they? Were they? Failed to present an expert witness. Didn't need to. Your expert did the job all on his own. And simply stated that plaintiff opposes and objects to several billing entries for costs and attorney's fees offered by defendants. Isn't it sad that that's all it took? Simply opposing line item entries, however, is insufficient to reduce the fee award. Notice what's missing from this. Notice what's missing. Look at all that paper. Look at all that paragraph. All of that paragraph. In fact, look at all this paragraph. Well, look at this entire page. You notice what's missing from this entire page? Not a single damn citation. Not a single cite to any authority, persuasive or authoritative. Not one citation says why they should win. Not one. Not a single damn thing. Imagine my shock. JCF Data says final judgment awarded plaintiff $100K, so Chupp gave Vic $100. Is that what it says? Final judgment awarded plaintiff. That's pretty funny. Good catch, buddy. Good catch. I didn't even see that. Oh, God. Not an argument. It's not an argument. Defendants applied a $24,018.95 reduction to arrive at their requested fee award. Pay attention, y'all. The defendants actually requested they actually billed, according to them, unless they're lying, $295,000. $295,000 for this. That's what they're saying. We reduced it by 8%. That should be good enough. Defendants already accounted for specific line item inefficiencies. No, did you account for how long it takes Lemoine to go up a flight of stairs? No, that's an inefficiency. Hire an attorney who can breathe. For God's sakes. Hire an attorney who can walk to the stand. Therefore, the court should have awarded defendants their full fee amount, $279.63. I mentioned this when we were going through their billing just briefly, that they've reduced it. What they try to do is preemptively reduce the amount so that the court can apply like a roughly 10% discount. Oh, they learned how to use the Microsoft Snip tool here. That's nice. Final judgment language awarded defendants their conditional appellate attorney's fees should be modified to apply only to plaintiff's appeal of the dismissal order. Defendants further request the court modify the language in the final judgment to clarify that defendants are entitled to their appellate fees if they successfully defend against plaintiff's appeal on a dismissal order, regardless of defendant's own cross appeal. Specifically. Now, again, I focus on this line. In the event the plaintiff files a notice of appeal. Specifically, the final judgment provides this. So on October 25th, 2019, plaintiff filed a notice of appeal of the dismissal order of the 2nd District Court of Appeals located in Fort Worth, Texas. Specifically, which is notably 30 days prior to this order being issued. Specifically, plaintiff asks the Court of Appeals to reverse this court's dismissal of the lawsuit and all subsequent orders. Per the final judgment, if defendants successfully defend against plaintiff's appeal, i.e. the dismissal stands and there is no modification to the judgment dismissing the lawsuit, defendants Riel and Toye are entitled to appellate fees of at least $55,000. Final judgment awards defendants $100,000 in reasonable and necessary attorney's fees. The language in the final judgment, however, does not account for defendants successfully appealing that award. Oh, that's funny. That's right. That's a funny. Good catch. Good catch, Wick Phillips. So, here we go. Think about this. If, in the event, there is no modification of or change to the judgment, or the judgment is affirmed by the Court of Appeals, they get $55,000. Now, if Lemoine succeeds in appealing the fee amount, and say wins another $10,000, then they don't get the $55,000. That's brilliant. I never even caught it. Oh, that's good. That's good. If the fee amount changes at all in any direction, they lose their conditional appellate fees. That must suck. In that case, wouldn't it be funny if the appeals court gave them, like 10 grand extra? They would lose their $55,000. Oh boy. Oh boy. In fact, though, I'm not sure that this applies, mainly because of this language. This is highly prejudicial to a plaintiff enacting their right to appeal. Second, this is basically, it's like a bill of attainder. It's a post facto judgment. They already filed their notice of appeal. They can't unfile the notice of appeal. So you can't award conditional fees on something that already occurred. Let me entertain a possibility. At the time this was pending, remember this, because I'm sure this won't get brought up. Walk with me here. At the time that this was pending, in the defendant's motion, they mentioned that the appeals will properly get dismissed by the appeals court. The defendant mentioned, I believe, that they were confident the appeals court would dismiss the premature appeal, if I'm not mistaken. Should we go to the record or should we just roll with it?
We're just gonna roll with it because I know I'm fucking right.
I know I'm right. They argued with the specific wording, because I got a mind like a steel trap for shit that shouldn't matter. They argued with the specific wording that they had already filed their motion to dismiss the premature appeal and were confident the appeals court would dismiss it. They were confident the appeals court would dismiss it. Well. Despite the fourth-year attorney up in Minnesota who knows nothing about Texas law telling them over and over that the appeals court had jurisdiction and there was a specific rule on point, they said they were confident. My theory, Judge Chupp doesn't touch this order because they insisted that Vic would have to file a new notice of appeal because they're stupid. And because Wick Phillips is a far better grifter than I could ever be. Think about this, guys. I have grifted Vic Mignogna. We're at $267,135,000 raised from 5,800 donors, okay? 5,800 people. Let's get the calculator going. 267. Come on now. 267. 135 divided by 5,800 equals $46 a person, right? Okay. I have grifted $46.06 from 5,800 donors. Lemoine has charged 295,000 people, or $295,000 to 2 people. That is 295. Come on now. Divided by 2. That is $147,500 apiece. Lemoine has grifted. Oh my God. Divided by 46. 47,500. Look, I am 0.00003% effective at grifting as Lemoine. Lemoine grifts at 3,200% the rate that I do. Lemoine grifts so much more effectively than me that it's sad. I was only able to get $46 out of 5,800 people. This mother effer was able to get almost 150 G's out of 2 people each. That's amazing. Amazing. Wow. JCF Data says, why does Clause 2 petition for review penalize Vic if any party files? Because it's stupid. It's stupid. And that probably won't stand on the appeal anyway. Look, I need grifting lessons from Lemoine. They think that I'm the master grifter. Lemoine grifted way better than I ever will. He's got 20 years of experience practicing law? Got 5 years of experience practicing breathing through a tube or whatever. He's way better than me at this stuff. All right, anyway, let's get back to it. The final judgment awards defendants $100,000 in reasonable. The language in the final judgment, however, does not account for defendants successfully appealing that award. Defendants filed a cross notice of appeal on December 13th, asking the appellate court render judgment that defendants be awarded the full amount of their attorney's fees, totaling $270,963.04. To finish my thought from before, I think Chupp did this. I almost want to say Chupp did this on purpose. I don't know. I can't tell if he's an idiot or if he's the smartest person in the room. I legit can't tell. But if all of this is conditioned on the plaintiff filing a notice of appeal, all Chupp has to do is say, you said you'd get it dismissed. And in the event that you got it dismissed, because you were confident in it, and that he filed a subsequent notice of appeal, subsequent to this order, as is proper, to have a court order let people do things after the order, then this would all go into effect. Then none of the awards for conditional fees matter because appellate court had jurisdiction already. They're going to re-review everything anyway. That's it. I think maybe Chupp did it on purpose. I don't know. Like I said, I can't tell if I should mail him the Labyrinth game or if I should mail him some silly putty to eat. I can't tell if he's smart or stupid. All right. If defendant's appeal of attorney's fees award is successful, e.g. the appellate court renders judgment on the amount requested by defendants, there would necessarily be a modification of or change to the final judgment affecting the court's award of conditional appellate fees. Final judgment, therefore, should have specified that the conditional appellate fees shall be awarded in the event there is no modification or change to the dismissal order, i.e. defendants successfully defend against plaintiff's appeal. Defendants, therefore, respectfully request the final judgment to be modified to read as follows. I think Chupp was hedging his bets on what the final judgment was as well, because he legit didn't know. Real Ontario shall also have and recover from plaintiff Victor Mignogna the following reasonable necessary appellate attorney's fees in the event that plaintiff files a notice of appeal. They should have smartly removed this language. They need to remove this language. I would argue to every Supreme Court that the plaintiff did not file a notice of appeal subsequent to the court's order and cannot be held to account for what came in an order subsequent to the plaintiff's action, because the plaintiff could not withdraw a notice of appeal that was already filed at the time. It's a literal impossibility to have a contingent fee based on something that already occurred. I would argue that to my dying breath. And they didn't do it. In the event there is no modification or change to the October 4th, 2019 dismissal order or the dismissal order is affirmed, blah, 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 blah. There you go. Prayer for relief. Based on the foregoing, defendants Monica Rial and Ronald Toya respectfully pray that the court grant a partial new trial solely to determine the defendants be awarded the full amount of attorney's fees, or modify the final judgment as requested, and the court grant defendants all other appropriate relief. I think the court has granted them all of the appropriate relief, frankly. All right, I'm going to read this super chat right now because I see it and it's kind of it's a thing that matters. Cole Kiddo says, Nick, thanks to your help, hey, cool, we were able to book Vic at my local con, Imperial Valley Comic Con, on Facebook. Already a few people throwing out that word predator. Anyone mind posting a few words of support? So again, to my legion of people that I definitely direct, if you feel like it, if there's Imperial Valley Comic Con on Facebook, they have booked Vic. I can't tell you what to do. I can ask that you show support to the con. Cole Kiddo is asking if anyone minds throwing some words of support in the comments. But look, the best thing you can do is check out the con. If the con is in your area, if the con is something you can attend, buy a ticket and go. Voice your support for Vic specifically. If you want to just throw a like on their page, you want to throw a comment that says, hey, thanks for bringing Vic, great. If you don't. You're you. You're a person, not mine. But check it out. It is great to see Vic getting booked at conventions for 2020. I will hopefully be announcing conventions that I will be booked for in 2020. One that I am 99% positive I'm going to I don't know if I'm a guest of the convention or if I'll just be there. One of the two will be GaryCon up in Wisconsin, end of March. It is GaryCon is Gary Gygax, the creator of D&D. It is a D&D tabletop role-playing convention. I believe I will be there. I believe Ty Beard will be there as well. So if you guys want to go to GaryCon and see me, go to GaryCon. I'm like super close to just being able to definitively say I've got like everything nailed down for it, just about. But yeah, GaryCon. Also, I believe Lady Rackets will be there as well. So if you want to just, see the pretty one, you can come see her. If you want to hang out with the funny one, you can come see me. How's that? But GaryCon, I believe, will be there. And I will announce any other cons that I can confirm when I can officially confirm them. I'm trying to confirm one up in Canada. I'm really close to nailing it down. Just got to lock down exactly what's going to happen with my kids. If they're coming with me or if they're hanging out with someone else, I got to figure that out before I can 100% confirm it. But it's definitely on my big to-do list, and I'm working it out. So, all right, guys, that's that. There is should we go ahead and open this real quick? We've got that Chris Hook document real quick. Chris Hook, Chris Chan. Don't I have a Chris Hook folder? I don't. Do a new folder here. Hooker. Okay. Let me get this document pulled up. This is an update on Chris Hook. Failed. Why would you fail to download a simple document? Just disgusting. Are you serious? All right, we'll do it this way. Give me just a second. Hate doing it this way, but whoa. This will be good. Okay. Here we go. It's in the matter of Christopher Hook, right? The Allstate case. Now, again, as a recap, we played the audio of Christopher Hook's hearing on the Christmas live stream. So if you mentioned it, if you missed it, go back and check out the Christmas live stream. You can watch, you can listen to the audio of Chris Hook in front of this judge. All right. But I want to clarify what the actual orders are. These are the civil minutes, General. These are the minutes submitted to the court that clarify the proceeding. And here is the order, right? So this is what is actually ordered. So proceedings in chambers on December 16th, 2019. Hey, that's my birthday. Defendant Allstate Insurance Company and plaintiffs Alan Baker and Linda B. Oliver appeared before this court to address Allstate's ex parte application requesting dismissal of the case, disqualification of Christopher Hook as plaintiff's counsel, permanent injunction against Hook, and sanctions. Notice 1, 2, 3, 5. So solid work by the court in providing the 4 but labeled 5 issues before the court. Good job. The court denies as moot Allstate's request for dismissal because plaintiffs terminated Hook's representation, knew nothing about Hook's egregious conduct, and obtained new counsel, Mr. Matthew B. O'Hanlon. Of course they dismissed it. Hook's conduct wasn't prejudicial to the defendants and certainly wasn't doesn't disqualify the merits of the plaintiff's case. Plaintiffs either have a case or they don't. And Hook's comments, although crude, have no bearing on the merits of the case. So next, accordingly, Allstate's request to disqualify Hook as counsel is denied as moot. He was terminated. They can't disqualify him. He's gone. And the court lifts the protective order suspending depositions. Mr. Hook is terminated as counsel for plaintiffs, but shall continue to receive electronic case filing notices in this matter until further order of the court. Because he is going to be ordered to pay attorney's fees. That's why he shall continue to receive electronic case filing notices. They don't want to remove him, give him some excuse to not pay the fees. They're gonna serve him the fees through the electronic filing system. After here, this is the important one, okay? Because if you listen to that audio, you may think that the judge issued a restraining order against Mr. Hook on behalf of Allstate counsel and their families, right? Which would be ridiculous. But listen to this. After considering the parties' briefs and arguments at the hearing, the court finds that the granting a permanent injunction within this venue under these circumstances is inappropriate. A permanent injunction against Hook. This is, I believe, the restraining order. They were saying that Hook should be enjoined from discussing matters with Allstate's counsel. Right? This was their restraining order. The judge said he would grant the restraining order. After considering the parties' briefs and arguments, the judge didn't come to some measured consideration that maybe the restraining order is too harsh. He realized that he had no basis for a restraining order. Absolutely none. No cognizable threat was actually issued in the emails by Christopher Hook. He also didn't admit to actually making them. He didn't act as a witness against himself. And the court cannot properly issue a restraining order based on the evidence it had, even if that evidence were true. 100%. They don't have sufficient cause to issue a restraining order. It just isn't. I said it on the Christmas stream, and I'll say it again now. If a normal person walked in with that list of emails and said, I want a restraining order against this person, they would not get it based on that set of facts. They just wouldn't. A normal man. Now, if a woman walked in and the man had been sending the emails, maybe, just because the court isn't supposed to, but it favors women in restraining orders. It just does, especially a 75-year-old former Marine, former cop. Trust me, he's going to favor women over men in restraining orders 99% of the time. He's just going to. That's how it works out. But Allstate's request for a permanent injunction is denied. Nor has Allstate met its burden to obtain a permanent injunction. So despite what the judge said in the courtroom, they don't get it. Of course they don't. It was unreasonable. The judge was just heated up and grandstanding. He wasn't going to get that. During the hearing, Hook stipulated to paying monetary fees, sanctions to compensate Allstate for its reasonable costs and fees associated with its application for ex parte relief. Accordingly, Allstate is ordered to file a memorandum of costs and fees and a proposed order with the court within 14 days of this order. Lastly, the court will be reporting Hook's misconduct to the California State Bar, will recommend disciplinary action. Remember, the judge wanted Hook to resign as an attorney. Said you shouldn't be an attorney. You brought shame to the profession. To the profession of people who defend rapists, who defend murderers, and all sorts of other shysters. Somehow a guy saying gay boys over and over in email brought shame to that profession. But he realized, of course, the court cannot order an attorney out of being an attorney. Can't do it. This is the most damage he can do to Hook. He can report Hook's misconduct to the California State Bar and recommend disciplinary action. Hook will have the full due process that attorneys are allowed in the disciplinary board's process, right? He can actually suggest that the judge has no standing to bring the misconduct before the state bar. Probably won't get very far with that argument, but he should try it. He can argue all sorts of things, but most importantly, he doesn't have to argue it in front of that judge. He gets to argue it in front of an allegedly neutral body enforcing disciplinary actions to determine if he actually violated his professional conduct rules. Pro tip: probably did. Disbarable? Probably not. Will he get a suspension? Maybe. A suspension, a couple months, 6 months, maybe suspension. Ordered rehabilitation where he works with another firm to rehabilitate and learn the proper way to communicate with opposing counsel. Ordered to attend some ethics, continuing legal education courses, something like that. Sure. Disbarred? Tall order, man. Tall order. Very, very questionable whether or not he did anything actionable. Remember, look at what's in this order. This is really, really important in this order. Remember, the judge is admonishing him for the egregious activity of threatening counsel and their families, right? A threat. That was part of the basis for all of this. They were scared that he was going to waterboard the peoples, the deposition peoples, and that he was threatening plaintiff or defendant counsel, right? But the court lifted that. The court rolled that back in this document, saying that Allstate didn't meet its burden for the permanent injunction, meaning Allstate never proved there was an actual threat of violence. Well, if there's no actual threat of violence, then there's no crime that was committed. If there's no crime that was committed, what the disciplinary board has to do is determine whether or not his non-criminal statements rise to the level of disciplinary action. That's really questionable here. The court's already punishing him with sanctions, monetary sanctions. He's getting punished for this. Should he similarly be disciplined by the ethics board? What for? He was zealously representing his client. Sure, maybe he broke decorum rules of the court. Maybe he spoke too harshly in settlement. Maybe he did this. He didn't commit a criminal act. We know that from the order. Allstate didn't meet its burden to show that. So what did he do? He used mean words? Discipline for it should be disbarred. No. This guy will probably get to remain a lawyer. He may get some sort of disciplinary action, like I said. like I said, some continuing legal education, some sort of maybe a rehabilitation with another firm, and maybe even a very limited suspension of his license. 3 to 6 months could be possible for sure. No idea. Or a conditional suspension where he's suspended outside of having that rehabilitation counsel on board to help him out, something like that. But yeah, all around, the order that comes out is pretty mitigated from what the judge said in court, and I think that's pretty important. Actually, I think that's very important because judges do not have the power to do this. And attorneys, as much as no one wants to admit it, we get free speech rights just like everybody else. And the judge may say that you think the First Amendment applied to anything? Did you even go to law school? Yeah, that's why he knows that the First Amendment does apply. And the judge can't just restrict the speech of an attorney because he doesn't like it. Can't do it. He gets due process. And he didn't get the process that was due in that courtroom. So, and he can actually appeal the sanctions and attorney's fees. But he did say he would do it on the record. That's his one criticism. One criticism is I wouldn't have agreed to pay anything because I'm a dick. No, Your Honor, I don't agree to pay anything. Absolutely not. But so there you go. So that's what we got, guys. So now what I'd like to do, if you don't mind, is we're going to go through the super chats. We're going to read them, and then we're going to end the stream. If you do leave during this period of time, before you leave, click like the video. Don't, that's a simple thing you can do to really support the channel and the show. If you don't want to, that's fine. I agree. But click like if you haven't. If you do leave for the super chats, I will see you next time. I will be on Twitch tonight. Maybe playing Risk of Rain. Maybe playing Dawn of War 2. I haven't decided yet. I like Risk of Rain. But I'll be on Twitch tonight for a little bit. We'll have a good time over there. So if you want to come check that out, come check that out. Also, really closing in on Maddox, a couple hundred away from passing Maddox in followers on Twitch, which is still part of the goal. And the Twitch channel, hopefully soon, will be getting some retooling and revamping and some increased activity and some more firm scheduled stuff during the daytime. So if you do like Twitch and you like me, which I know those two things together is a rare combination, but if you like both of us and you want some video game content, that's just me playing games and making jokes and stuff, come check out the Twitch channel. And see how that grows and changes over the next year, right? It's a next project. All right, let's read these chats. If you open a Chatterbait channel, I will not follow. Oh, I'll email that Chatterbait channel to you constantly, though. Andrew War Snowboard says, "Is Judge Janine a real judge?" Judge Janine Pereiro was a judge. I believe she was an elected judge for one term, and then maybe more than one term. She was an elected judge, and then she is no longer a judge, but she was, which just means that she was elected to win a judgeship. Christian Delgado says, "Is there any more motions that Lemoine can file, or is that it, Nick? Because this is annoying now. Next will be a motion to reconsideration motion." You can always file motions. Whether or not they're frivolous is up to the court. Insert clever name here says, "Just a chat to say hi since it's been a while. Merry Christmas. Hope you feel better soon." Hey, hi. How's it going, buddy? And I think I'm on the recovery. Another day or two and I should be normal. Stephen Welsh says, "Con sluts rise up. P.S. I'm addicted to Milos because of you." Oh man, I'm so sorry. So sorry. Cardinal Crimson says, "Shout out to those in the UK. All the anime is having a Funimation Everything Must Go sale. 80 to 90% off till January 6th. Box sets from $3.99 of English pounds. British pounds? Whatever it is. 399 pounds would be not enough to encompass the Jamie Markey. But $3 or 3.99 pounds is certainly reasonable." Rogue says, "If I remember right, Ron never finished school." Blaine 20 sends a wrecked sticker. Foxwood sends a next time sticker. Thank you guys. Talon's here says, "I like the idea of the fan email in the Discord." Yeah, well, it'll happen in the Discord, probably on the next live chat Wednesday. Darkman McEdgeface says, "Nick, it's been 6 months at a few $100s. When are you coming on Graded Point 5? How do we book you for an evening show after the new year?" Oh God. It's not you, it's me. Just really bad at keeping track of bookings. In fact, I think I'm on some show on January 6th. Just re-email me. I'm sorry. It's just hectic. It's just hectic. I would love to come on your show. Absolutely. Big Woke says, "Just got home from a date. Glad to see you're feeling at least a little better, Nikki. Here's some dollary dues and Merry belated Christmas. Hope it was a good one for you and yours." Man, it was. My kids get to spend time with my parents. I mean, I'm here too, but my kids get to spend time with their grandparents, and you can't ask for anything more than that in this world. When grandkids want to see grandparents and grandparents want to see grandkids, it's a beautiful combination, and that is Christmas for us, and that is wonderful. Alinka Pavlova. Oh, I'd be remiss if I don't ask. If you're out there, there's someone in this audience who works at Universal Studios. Sent me a message about Universal Studios tickets a long time ago. If you happen to see this, buddy, I'm going to go through my messages and try and find it, but I fear it was on my other Twitter account that got deleted. If you happen to see this, please message me again, either on Discord, on my new Twitter, on Facebook, somewhere. I'd love to talk to you. And I'd love to coordinate with you. We've got a trip coming up where I think Universal Studios is on the docket. So I would love to coordinate with you on that and at least say hi and visit you and maybe grab a drink or something. So if you're out there, I hope it wasn't on Twitter. If it was on Discord, like I think it might have been, I will definitely find you. If you're out there, please hit me back up in some DM form so we can find you, or email me. Either way. Kalinka Pavlova says, "Oi, it was the shit guns and we can tame emus." Oh man. Oh, shots proverbially fired at Australia for being unable to tame emus. Bad Vibe says, "Don't worry, Lemoine, China will buy Moronica's bill." Alabaster Scarf says in Lemoine voice, "She was a conslet of Rome." Too much weed, Nick. Can't remember. It was a year ago. Oh, man. Corey Goodman says, "Felt the need to thank you for inspiring me to try scotch. I decided to go light being a newbie and all. Glenlivet 12 and Founders Reserve." Hey, Glen 12 is great. Great entry scotch. You're welcome. I've ruined your wallet. Guidus says, "Never tried Lagavulin, but I have had Ardbeg. How do they compare?" Lagavulin, it's a little smoother than Ardbeg, but also a little rougher. That makes sense. It's smoother on the alcohol, a little rougher on the peat and the smoke. I love Lagavulin though. If I'm being honest, I'm not a fan of the Ardbeg. It depends what you don't like about the Ardbeg. More peat and smoke in the Lagavulin, in my opinion, but also smoother on the alcohol taste. Automata says, did you use a tongue into cornhole reference as an expression of anger between the judge and Mr. Hook? What have you seen to make that connection? You don't want to know what I've seen. You don't want to know what I've seen. Comic-Con Freak says, could you please give a shout out to my friend whose mom has been in the hospital all week? Thank you. Love your show. Comic-Con Freak, to your friend whose mom has been in the hospital all week. Shout out. I hope she feels better. Prayers for her and a speedy recovery. Not fun to spend Christmas in a hospital. I have done it. But, hope she feels better, buddy. Mario Carter 13 says, Ty, it pays to be premature beard. Some Moon Runes sent me $2 Canadian. Thank you so much. I don't know what your words say, and there's no message attached, but thank you. Mario Carter 13 says, don't choke on that pound of flesh. Grip the shaft. Then we've got Stars Girl Forever. Says, belated Merry Christmas. Hey, you too. Hope yours was blessed. It was. Thanks for entertaining me for almost a year. Keep it up, Nick. Your videos are refreshing. Oh, thank you. I will keep it up as far as I know. Look, I'm a coomer. I will keep it up all the time. Asphyxiation says, to protect the honor of my country from your earlier accusation, Fireball Pie was my stepdad's genius idea, and he's from Arizona. Your fault. No, he isn't. No, he isn't. If he is, he's from the bad part of Arizona, which is called Australia. Matt Field says, just bought a ticket to Imperial Valley Comic Con. Hour drive away, and I have vacation entire month of February. It's not a coincidence. Hey, awesome. Go have fun. Go say hi to Vic for me. I appreciate that. That's awesome. Trashtown TV says, seriously, chat, Milo's is a wonderful alternative to regular sweet tea. All the taste and refreshment without the sugar and calories. Give it a try, heart. Milo's. Hit me with that sponsorship. I will sell your tea like no tomorrow. Big Woke says, extra $10 for a wholesome reply. Or maybe it's the whiskey. Hopefully both. And some nobody. Thank you very much for your donation. Oh, it says, think your emailer's username is on my block list, by the way. Could be. All right, guys. Oh, wait, we got the Justice Chats. Crusader Saracen says, like you, I am also laid low by disease. But these next few days are mandatory attendance at work, Federal Indian Casino, with risk of termination if I fail to show up. I have a doctor's work release note until January 3rd. What federal protection do I have? Maybe FMLA, the Family Medical Leave Act, but you work on an Indian casino, which might not, feds may not have jurisdiction over that. Just go in and cough on like 5 customers. Just spread your small cough into a blanket, right? Rub the blanket under your armpits and cough into it, and just hand a few blankets out to casino goers and see if they keep you there. That's my brilliant idea. You definitely won't get fired for that legal advice. Weaver of Time says, what do you think about the Onision case? I know he's unlikable, but nothing is coming out of this supposed FBI investigation is beginning to feel like a hit job. I haven't had time to look into it fully. I've gotten some requests to look into it, and I plan on it, but I need to really dig into it. Hard thing about supposed FBI investigations is the FBI will never confirm or deny an investigation, and until you see an actual indictment, you'll never know. You'll never know for sure if they're happening. Night of Hopex. I think part of what the other side is arguing on banning porn is that state actions against indecency existed when it was ratified, would not have been considered protected speech. I think injury and actionability are the best arguments against this. Of course, course. Also, the fact that we look to how the founders worded things for guidance, but we are not bound by what the founders said. And as evidence of this, look at any of the other imprecise interpretations of the Constitution that we've had. The 13th Amendment was for black people. The 14th Amendment was for black people. And the 15th Amendment was for black men. Okay? But the 13th, 14th, and 15th Amendments apply to all. Well, the 15th is pretty specific, but the 13th and 14th apply to all sorts of people that were never intended. Never intended. That's just how it is. And that's probably a good thing. We look to the founders for guidance, and we should. I'm an originalist, I'm a textualist, and that's how I tend to swing. But at the same time, we looked at the founders for everything and said, well, only the things the founders specifically thought of are considered. In one, we ignore the founders who say that the Bill of Rights isn't a limiting bill. It's not a limiting document. We ignore guys like Madison who didn't want a Bill of Rights because they thought that the Bill of Rights would limit people's perception of rights to what was written down, rather than you have a whole lot of rights that are already protected in the Constitution. You don't even need this Bill of Rights because they already exist. So we're like selectively originalist. I just don't think it's that big of a deal. But then Knight follows up with, also that's kind of interesting. In order for something to be actionable by the state, it has to be injurious in some way, right? That's not the only test, but sure. Who then does the government argue prostitution is injuring? That's a good question. I've never heard this argued before by anybody. The arguments against prostitution in court, arguing that it doesn't injure anybody because it's consenting adults, sure. They argue that it injures all sorts of things, though. Injures society, it brings a criminal element, it attracts other types of crime, all sorts of stuff. It's same thing, same reason, same way they argue against like strip clubs in cities, right? So some cities have strip clubs that have to be in specific areas or outside because they're too close to a school or too close to a liquor store or whatever. They're not good arguments. They're arguments that the courts have found convenient to uphold for their own personal beliefs. Night of Hope X finally says, I don't want to live in a country where you can't call a bunch of butt weasels what they are to their faces and stay an attorney. If Allstate wants to get out of paying their claims, they should be ready to get embarrassed in public over it. Scumbags. Yeah, absolutely. Michael Rule says, I myself work with people who have a disability in one way or another. If the judge's fees were heard over this, then he should meet my coworkers. And the Night of Hope X says, oh yeah, after originalism, you still run into the vague definition of obscenity and how that's been ruled on, which in and of itself shouldn't be actionable either. Yeah. Yeah. Like I said, I've got a short video that is in the works. I just want my voice to sound better to do it on why porn is legal, why porn is protected speech, how we got there, and that'll be the video. There may be another video as to why it should stay that way. I don't know how much advocacy I want to do in that video, but I want people to know about the court decisions, what the court was deciding. There are arguments against some porn that's out there right now too, but we're just overcautious on protecting speech, as we should be. But anyway, I think that's it, guys. Oh wait, no. There was one more from Nick Sax. Says, first time watching in your time zone. Hi from St. Louis. Hey, hi. Welcome. All right, guys. Thanks for hanging out tonight. I'm going to wrap up in a little bit, maybe 15 minutes or so. I'm going to start up some Twitch thoughterly. I don't have a thought top. Don't hold me to that. I don't have one with me. Should have bought some at Target. I've been at Target so much on this trip. Should have bought some, but I haven't. So there's no thought top today, but you can come hang out with me on Twitch, play some games. Otherwise, I will probably see you Monday. I don't foresee a live stream tomorrow. I kind of love to do one, but wait, I don't know if I'll see you Monday. I don't know if I'm going to do... Wait, that'd be the 30th. That'd be the 30th. I'll probably do one on Monday. I don't know if I'm going to do one on Tuesday. Because I'll be hanging out with the fam at midnight. Or with someone else. I don't know. We'll see. Anyways, thanks, guys. I don't have the outro music here. So you'll just have to deal without it. I'm sorry. Whiskey Drinking Lawyer. It's available on SoundCloud. The link is in the description. I've delayed too long. Peace. Peace.